Hi, I'm attorney Greg Dell, and we're going to talk about Principal Financial long-term disability denial claims. Now, I've handled thousands and thousands of long-term disability denials, and when it comes to Principal Financial, they're one of the just around the top 10 largest disability insurance companies in the country. They're one of the more boutique type disability insurance firms where they primarily focus on long-term disability claims, and because of the fact that they're a smaller type operation, they tend to put more attention into their long-term disability claims. And as a result of this, that means that they often draft more detailed denial letters. So when that happens for a claimant, you're faced with a situation where it may not be as easy to get a claim reversed. And I say that because a lot of the long-term disability insurance claims by, say, the top 5 disability insurance companies, they write very shoddy denial letters, meaning they're very short, they're cherry picking in particular records, and they kind of have like a system for denying claims. Principal, on the other hand, is actually one of the better companies, and they actually, more often than not, will try to give a claimant the benefit of the doubt. So you can definitely get your Principal Financial disability denial reversed, but you have to take very succinct steps in order to do so. So in this video, though, I want to talk about what are the most common reasons that I see for a Principal Financial disability denial. The first reason that comes to mind is that there's insufficient medical support in the records. So basically, if you're looking at a denial letter right now from Principal, or you're worried that you're going to be denied your Principal disability benefits, you're probably going to see something in a letter that says, look, we see your subjective complaints, we see your diagnosis, but we don't believe that your subjective complaints are supported by objective medical evidence. What does that mean, objective medical evidence? Let's use as an example if you have a back condition. If you have a back condition, objective medical evidence would be an MRI, an X-ray, something that is a diagnostic study that then shows a result. Whereas a subjective complaint would be you go to the doctor and you say that my neck hurts. When I turn my neck, it's hurting me. Those are subjective complaints because there's no way to verify whether or not the complaints you're saying are actually true or not. But when you have an objective finding in an MRI and say it's your neck and it shows you have a herniated disc, or you have neuroforaminal narrowing, or you have stenosis in your neck, then you have an objective finding. And the issue then becomes, are your complaints reasonable in light of your objective findings? So that's just one thing. But in order to really get good, strong medical support for your claim, in order to prevent a denial or get your denial reversed, you have to have it all documented in your medical records. I always tell everybody, your claim is only as strong as what you have in your records. Another way I say it to keep it really simple is you need to look messed up on paper. That means when someone looks at your medical records, it needs to look like this person is in bad shape. Now, I'm not telling you need to exaggerate something in the records, but more often than not, what I see is that your complaints are not documented well in the medical records by your doctor. But you'd say, Greg, why does this happen? Why wouldn't my complaints be in the medical records? And here's why. You have a relationship with your doctor. When you go to the doctor knows you. I always tell claimants, look, these doctors don't work for the insurance companies. They don't have to have their medical records reviewed by insurance companies in order to get paid for the services that they're rendering for you. As a result of that, they do what they have to do to take care of you as the patient. They treat the patient, not the chart. The insurance company cares about the chart and doesn't care about the patient. So in the day-to-day course of treating patients, the doctors that you see put sufficient information in the medical records just to remind them as to what course of treatment they gave you and what next actions they want to take when they see you. As a result of that, your medical records become basically easy cherry picking for any hired disability insurance company doctor or nurse to look in the medical records, and if they know anything about a medical condition, to pull out a few things that they say are not in your medical records, and as a result, you're lacking the support for your disability. This is a chronic problem within the disability insurance world and something that I see claims denied for all the time. So when we get together with a client and we're helping them to get their denial reversed, we communicate with your doctor, we build a custom attending physician statement. We also work with you to go back to your doctor, to articulate all of your complaints to your doctor, to make sure your doctor does a more thorough exam, to make sure your doctor knows what to document in the medical records. But the custom of attending physician statement that we do is basically pulling out all the information that we know your doctor likely has, but just hasn't put in the records. And as a result of that, we're now speaking directly to Principal Financial and saying, look, you should not have denied this claim for the reasons that you did, and here's all of the doctor support which addresses all of your concerns. Because at the end of the day, it's about addressing the concerns of Principal such that they get all of the evidence and they can't be in a position where they look at your records and go, this person can work. They have to look at your records and say, yes, this person has the condition and all of their restrictions are reasonably supported. So that's one of the biggest ways in which we're able to work with you to give you the best chance possible to get your claim reversed. The other basis for denial that I often see is a change in definition, meaning your definition of disability started out as own occupation, meaning the inability to perform the duties of your occupation. After usually about 24 months, it changes to the inability to perform any gainful occupation. Any gainful occupation, does that mean go work at McDonald's, go work as a librarian? No, it means based upon your experience, education, and training. And also, it also usually has to take into consideration what your earning capabilities were. Now, sometimes your disability policy will say that you have to earn specifically 60% of what you used to earn. But if it doesn't say anything about what you used to earn, then they may be able to argue that you could do a lower paying job, which is something that you probably would never even apply for because you have so many more qualifications. But the real reality is when you think about that, is that if you had the qualifications to do a particular job, then you would apply. And there likely is, if you couldn't do the job that pays in the salary range that you're looking for, it's unlikely that you could do the duties of the lower paying job just because it's a lower paying job. So those arguments that they try to make about saying, oh, you could do this job, those usually don't hold any water because the requirements of the lower paying job are the same as the requirements of a higher paying job. And what we usually do to work to prove that you are disabled from basically any job is we retain a vocational expert who specializes in looking at what the available jobs are in the job market, looks at your restrictions and limitations, and puts together a report saying, look, here's the jobs that may be available, here's the requirements of these other jobs, and here's what our client can and can't do. And so they take this report, they analyze it, they also have their own in-house vocational rehabilitation consultant, and that's evidence that we put in to rebut what they say. So very important, you have to attack on the medical front, you have to attack on the vocational front in order to have a chance to get your denial reversed. The other basis of denial that I commonly see, and there's a lot, but this is probably the last one I'll touch on for this video, is that there's restrictions and there's limitations in these policies for specific medical conditions. For example, if you have a mental nervous condition, the likelihood is that they'll pay benefits for a period of 24 months for anything related to your mental nervous condition. After 24 months, they're going to deny benefits saying, we don't disagree you're disabled due to the mental condition. However, this policy only pays 24 months for that condition. Another thing that you can sometimes see in a principal policy may be a limitation due to a musculoskeletal limitation that's not verifiable by objective evidence. That's the same issue that I was talking about in the beginning of this video, where I talked about that you have to have some kind of nerve conduction study test, you have to have some kind of MRI, which is showing that you have objective findings of that physical condition. So these kinds of limitations, also substance abuse disorder, if you have an addiction to alcohol or some kind of other narcotic, that's another basis that they may deny your disability claim. So we've seen every single type of denial reason there is out there, and we're prepared to deal with it. The way in which we go about handling your claim is we ask you to send us a copy of your denial letter. We immediately get on the phone with you, we review it, we provide you with a free consultation. We let you know what we think would be a good course of action. We let you know what we think are your chances of success. We importantly let you know what our attorney's fees are going to be, which is we never charge any fees or costs unless we make a recovery for you. And the fee varies based upon how long you're going to be out of work, how much is your disability benefit, how old are you, how many months of benefits remain for you, what's the complexity of the case that's involved. And we always try to offer you a very fair and reasonable fee so that we can work with you to get your benefits paid in the most expedient manner and the most affordable manner for you as well. So if you have any questions about your claim, feel free to call me, any of my attorneys. No matter where you live in the country, we're available to assist you, and we look forward to speaking with you.